Hey everyone, and welcome. So let me ask you something. Have you ever made a promise you couldn't keep, or maybe had someone break a promise to you? Well, today we're going to dive into that really fine line, the line that separates a simple, everyday promise from a binding contract that the law will actually enforce. This is a huge topic for your law exams, an absolute must-know. So let's get right into it.
Yeah, just think about it for a second. You agree to buy your friend a coffee. They promise to help you move next weekend. At what point does that promise actually become something a court would recognize? What's that magic ingredient, that secret sauce that turns a casual, friendly agreement into a legally airtight deal? Well, that's exactly what we're going to unpack today. All right, so before we jump into the juicy stuff, the court cases, the real-world drama, we've got to lay the groundwork first. We need to understand what a contract is in the eyes of the law. Because, let's be real, it's so much more than just a piece of paper. It's a whole legal concept with its own very specific DNA.
And really, it all starts with this ancient but incredibly powerful Latin phrase, Pacta, Sunt, Servanda. It literally means agreements must be kept. And this right here, is the absolute bedrock of modern commerce. I mean, think about it. Without this principle, business as we know it would just grind to a halt. It's the fundamental idea that your word is your bond, and the law is there to make sure you stick to it.
So, this is where the Indian Contract Act of 1872 comes in. It gives us this really clear two-part formula right in Section 2H. See, a contract isn't just an agreement. No, it's an agreement that has the full force of the law behind it. I love this analogy. Think of it like a promise, but with a legal safety net underneath. Okay, so how do we actually get from a simple agreement to a full-blown legally binding contract? Well, it's basically a two-step journey. First up, you need an offer, and you need someone to accept it. Boom! That gives you an agreement. But, and this is a big but, that's just the starting line. To actually cross the finish line and have a valid contract, that agreement has to meet the super important requirements of Section 10. And that, my friends, is where things get really interesting.
So, what are these essentials we keep talking about? The things that transform an ordinary agreement into an ironclad contract. Well, this is where the law stops being general and gets really specific. Section 10 of the Act literally lays out a checklist, a list of everything an agreement must have to be legally enforceable.
Think of these as the absolute pillars of a valid contract. Seriously, if you take even one of them away, the whole structure just comes crashing down. You need free consent from everyone involved. The parties have to be legally capable of making a contract. And, of course, the whole thing has to be for a lawful purpose. If even one of these things is missing, nope, you don't have a contract. It's really as simple as that.
Okay, so theory is great and all, but the best way to really wrap your head around these concepts is to see them play out in the real world. So let's look at two landmark cases where the court had to figure out if a promise was a legally binding contract or not. And just a heads up, these are the exact cases you'll want to be citing in your exams, so this is the part you'll want to tune in for.
All right, our first case takes us all the way back to 1919, and it involves a dispute between a husband and wife, the Balfours. Here's what happened. Mr. Balfour was working abroad, and he promised to send his wife a monthly allowance while he was away. But then, the payments stopped. So she took him to court, and the whole case boiled down to this one big question. Was this just a simple domestic promise, or was it a legally enforceable contract?
And the court's decision here was a total landmark. They basically ruled that in domestic agreements like this one, there's no intention to create legal relations. What does that mean? Well, in other words, the law just presumes that you aren't planning to sue your spouse over a broken promise about a household allowance. It's a really crucial distinction, right? It separates our personal arrangements from commercial deals, and it definitely reflected the social norms of that time.
Okay, next up we have a case that deals with another fundamental question. Can a minor, someone who's underage, actually enter into a binding contract? So, in this case, a young man named Dharmadas Ghose mortgaged his property to get a loan. Now, the lender knew he was a minor, but decided to go ahead with the deal anyway. So, was that a smart move? Well, the court was about to weigh in. And the court's ruling on this one? It was absolutely crystal clear. They said the agreement was void ab initio. That's just a fancy legal way of saying it was invalid right from the very beginning, like it never even existed as a contract in the first place. See, the law is designed to protect minors from being taken advantage of, and this case established a super strict, unwavering rule in Indian law: you simply cannot form a valid contract with someone who's legally underage. Period.
All right, let's pull all of these threads together now. This is the part where we summarize everything. These are the key takeaways you'll want to have totally locked in for your exams.
So, to recap, Remember the formula. Contract equals agreement plus enforceability. And where does that enforceability come from? From the essentials listed in Section 10. And please don't forget our two huge landmark cases, Balfour versus Balfour for the whole intention to create legal relations thing, and Mahori Bibi for competency, specifically with minors. Seriously, citing these section numbers and case laws in your answers, that's what's going to show the examiner you really, really know your stuff.
But to leave you with the final thought, we've been talking about a law that's over 150 years old. So what happens when that law smacks right into the 21st century? I mean, in a world of smart devices, AI, and smart contracts, who or what even is a competent party anymore? Can a machine make a legally binding promise? Now that is a question that lawyers and judges are going to be wrestling with for years to come. What do you think?